Hello everyone, hope you are having an amazing week. So, in this session, we will be starting in depth with copyright. Okay, I'll just give you a brief overview. So, in this session, we'll cover the definition of copyright, two doctrines, its scope, and a bit about symbols of copyright. In the next session, we will go through its period of protection, neighboring rights, and ownership of copyrights. After which, we will cover some exceptions, infringements, and three groups of remedies. In the last session, we will cover some international conventions in brief and learn how to register a copyright in India. Cool. Alright, so let's jump on to today's topic. I know we have covered in brief about copyright in our previous sessions, but still let's go through it again to sort of revise it out. But before that, we know that intellectual property has two major sub branches, one of which is industrial property, under which trademarks, patents, industrial designs, and geographical indication comes. Then the second sub branch is copyright and related rights. Okay, so we will be talking about the second branch today only. So once again, let's look at the official and the formal definition of copyright. According to WIPO, World Intellectual Property Organization, copyright relates to literary and artistic creations such as books, musics, paintings, sculptures, films, and technology-based works, such as computer programs and electronic databases. So earlier copyright laws were only used to protect creative expression within either paper or print media. But of course, with the advent of internet, its scope has now broadened a lot. And now all sorts of digital content production, distribution, and retailing, they all also come under this right. So as I mentioned in the earlier session as well, copyright is also known as the author's right in some countries. Now, there are two doctrines to examine whether or not a work produced can be granted copyright protection. And the first one here is called sweat of brow doctrine, and the second one is modicum of creativity doctrine. So, the first phrase is a bit self explanatory. Here, instead of the intellectual or creative originality, the sweat, effort, and labor, or basically all the hard work, is taken into account. So one can put a considerable effort into gathering or compiling already existing information. Some good examples to explain this can be either encyclopedia or a telephone directory. But there have been instances where the sweat of brow doctrine has been rejected as well. One such example is that of Eastern Book Company case, where they argued that their work of copy editing raw Supreme Court judgments required a lot of hard work in terms of additions of paragraph numbers or cross references and formatting. And so their version of judgment summary should be qualified as copyrightable. However, rejecting this plea, Supreme Court established that the labor and the effort alone does not make a work copyrightable unless there is some sort of creative or intellectual originality in expression of the work. So this brings us to the second doctrine, which is modicum of creativity. Here, at least a minimal level of creative effort should be present in expression of work to be eligible for copyright protection, right? Here, only efforts and labor are not enough, though there must be some hint of creativity and originality here. Now let's jump on to the second topic, which is the scope of copyright protection. So, all right. Everything that comes under the official definition of copyright is, of course, protectable. That is sort of a given fact. Now, what all comes under protection? So, all sorts of literary works, say books, magazines, newsletters, trade journals, catalogs, etc., they're all protectable. Then, all sorts of musical works, all sorts of dramatical works, artistical works like paintings, sculptures, even computer and laser work, photographs, and computer programs, maps, motion pictures, applied arts like jewelry, wallpaper, they are all protected under copyright. So, what is not protected? Now, the most basic thing would be ideas, of course, as we talked about earlier. So, copyright protects the original expression of a particular idea, not the idea itself. We learned this in the previous session through R.G. Anand versus Dulux Films case, right, where the idea of secularity and interfaith brotherhood was not eligible to be copyrighted, but different plays and movies based upon such ideas were. Now, the second most basic thing which is unprotected would be facts. So, things like 2 plus 2 equals 4 or Earth is a sphere, these things are universal in nature and they cannot be copyrighted. So, in some countries, very basic use articles are also not copyrighted unless they have a very specific or a unique design on them, which, in which case they can be protected through industrial design. So a plain white t-shirt would not be protected, but if it had a Nike swoosh logo, then it will be. Then of course original government documents are also not copyrighted. So I hope this is clear. Now let's talk about the two rights under copyright protection, which sort of gives the original work an extra layer of shield. So the first one here is economic and the second one is pretty interesting, which are moral rights, sorry. Now, economic rights give the author or the owner an exclusive guarantee to restrict certain uses of their work. So, the author can prohibit others from selling or licensing, leasing, renting, or lending unauthorized copies. But keep in mind that in a lot of countries, this ability to prohibit ceases to exist after the first sale or the first distribution. So, after the work has been sold to someone else, the primary author cannot dictate where or how that work will be sold after that. This is also known as the doctrine of exhaustion. Derivative works also come under economic protection. So, if you make a work piece stemming from copyrighted work piece, like if you make a movie adapted from a novel, then you'll need to gain prior consent or permission from the primary author. Best example for this would be Harry Potter. Okay, now let's jump on to moral rights. So, moral rights are applicable to most of the countries, but the extent to which its scope is applicable, it varies from nation to nation. But most countries agree on at least two subgroups, which we will be discussing. So, the first one is authorship right, which basically means that you have the right to be called the author of your work. So, if your work is reproduced, exhibited, or shown to the public, your name has to appear in relation with the work. The second thing is that no alterations or changes can be made to your work that will damage your reputation or honor. Also, keep in mind that moral rights cannot be transferred to someone else, unlike economic rights. So, even if you sell your work piece or if you give away your economic rights, the moral rights are still yours to utilize. I hope things are clear until here. Alright, now let's talk about the last topic of today's session, which is regarding copyright symbol. Now, of course, to specify that your work is copyright protected, you'll need to have an indication or tag or a visual cue on it. So, copyright symbol makes sure that infringement to your work stays at bay. Now, what does it usually contain? The alphabet C, which is encircled, followed by the author's name and the year of publication. So, if I publish a book this year, it would sound like copyright symbol followed by Bhargavi and 2025. Also, to specify sound recordings, instead of the alphabet C, alphabet P is written encircled. So let's say that in a song, when we talk about the protection of lyrics, we'll use the circled C symbol, but to specify the sound recording, we will use the encircled P symbol. I hope this was also clear. So that's all for today. In the next one, we will talk about period of protection, related rights, and ownership of copyrights. Alright, thank you so much. I'll see you in the next one.